I've been receiving a lot of landlord-tenant questions on my channel lately. I'm going to respond to some of them in this video. Get ready for some answers. Hello again, everyone. I'm attorney Robert Flessis. If you're new to this channel, now would be a great time to subscribe, because when you do, you'll know where to go to get answers to your legal questions. You can also support this channel by posting requests to make more videos on even more legal topics that I usually don't cover. Consider supporting Super Thanks if you want in this channel. You can find the thanks button below each of my videos. If you can donate a small amount to me, and you don't have to, it helps me in the production costs to make even more in-depth videos that will help you. Well, let's start with this question. Amy writes, my landlord didn't give me enough time to read the lease. It has so many mistakes. Well, Amy, before you sign any contract, you need to read it to see what the terms are. Otherwise, if you don't, you're going to be bound by those terms. Even if a landlord is rushing you to sign the agreement, you still need to insist on reading it before signing. If you don't, and there are clauses that are not in your favor, once you sign it, you're done. Jan writes, my tenant falsified his employment information in the lease application. Can I sue my tenant or evict? Well, the first thing a landlord should do before entering into a rental agreement is to verify the information that a prospective tenant enters into the application. Doing your due diligence will go a long way to prevent entering into agreements with bad tenants. The question of whether you can sue the tenant may be moot. You already signed the lease with your tenant. If the tenant doesn't pay the rent, then obviously you can evict them. Ask the tenant now to update their employment information with you and then verify it. If your tenant is lying to you, then you might be able to terminate the lease by giving them notice according to your state's landlord-tenant law. Kendra asks a question about a retaliatory eviction. Her landlord verbally agreed that she and the other tenants could use part of the yard and patio, but when the other tenants complained about another issue, the landlord told everyone that they couldn't use those areas any longer. Is this retaliatory? In this instance, Kendra has an autistic child and her child uses those areas to play. The landlord's conduct could be considered a refusal to make reasonable accommodations for her autistic child. Sometimes a tenant makes a request for certain accommodations when they have some sort of disability. By law, a landlord must make accommodations that are reasonable. And if they refuse a legitimate and reasonable accommodation, then that could be grounds to terminate the lease. But every situation, remember, is different. Eduardo asks, if tenants can withhold rent when repairs need to be made, can they do that? Well, every state has different rules on that issue. But the bottom line is that a tenant could withhold part of the rent, but not all of it. The tenant is still occupying the unit and using it. It's unreasonable for a tenant to withhold all of the rent pending a repair. Now, let's say that the furnace is inoperable in the winter and a tenant told the landlord that they have no heat. The landlord does nothing to repair the furnace or even repair it within a reasonable time, then the tenant could possibly give notice to the landlord that the unit is uninhabitable, and that would allow the tenant to vacate due to a constructive eviction. Well, check out my landlord-tenant playlist on my channel. I have lots of videos that discuss different issues between landlords and tenants. I'm attorney Robert Flessis. Remember to share, like, and subscribe. Hit the Super Thanks button if you want, and keep posting your comments and questions. Thanks for watching, and I'll see you in my next video.